To apply the Charter to any particular case, we need to ask and answer three questions. The first question is always, does the Charter apply? We've already discussed, when the Charter applies and when it does not apply. Under Section 32, it applies only to Canadian government laws or actions. It does not apply to things that businesses, individuals, or other non-government organizations do. And that's because of the wording in Section 32 of the Charter. So if the answer to that question, does the Charter apply, is yes, we move on to the second question. Does that particular government law or action infringe a Charter right or freedom? So in answering this question, we're looking at the specific rights and freedoms that are guaranteed within the Charter and determining which of these rights and freedoms have been infringed by the law in question. And if the answer is yes, it does infringe a specific Charter right or freedom, we move on to the last question. Is that infringement of the Charter right acceptable as a reasonable limit under Section 1 of the Charter? So to determine if it is a reasonable limit under Section 1, the courts have devised certain legal tests that need to be applied to determine if something is considered to be a reasonable limit. We're not going to sort of go into the precise detail of what these legal tests are, but I've sort of boiled it down to the two most important requirements. First is that the law must have a pressing and substantial objective, and the second requirement is that the law only minimally impairs the Charter right or freedom. So if we have both of those things, then the law is considered to be acceptable as a reasonable limit of a Charter right or freedom. Let's look at a specific case to get a better understanding of how the Charter is applied. In 1989, the Supreme Court of Canada issued a decision in the Irwin Toy and Quebec case. That case involved the issue of advertising that was directed towards young children. The concern was that advertisers were gearing their commercials and other advertisements to exploit the minds of young children, to convince them to get their parents to buy toys or sugary cereals or any other stuff that they might want. To address that public policy concern, the Quebec legislature passed some laws that were put into their Consumer Protection Act, and that law prohibited anyone from using commercial advertising that was directed at persons under 13 years of age. So it basically banned any kind of advertising that was specifically directed towards young children aged 13 or younger. At that time, one of the major toy companies in Canada was Irwin Toy. If you haven't heard of Irwin Toy, you might have heard of some of their actual toys. Something I remember as a kid was Star Wars action figures. That's Irwin Toy sold those in Canada. They were also responsible in Canada for the Slinky, the hula hoop, and the frisbee. So what Irwin did was it challenged the legality of this new Quebec law in court. It put forward several arguments, and one of their major arguments was that this new law was contrary to the Canadian Charter of Rights and Freedoms. So let's now apply those three questions we had looked at to this Irwin Toy case. The first question, does the Charter apply? So again, we look at the relevant section of the Charter, which is Section 32, which determines where or what the Charter applies to. Specifically, under 32(1)(b), it says that it applies to the legislature and government of each province. So we know that this in the Irwin toy case, it involved a law that was passed by the Quebec legislature. So therefore, the charter clearly applies to that law. Let's now consider the second question. Does that Quebec law infringe a charter right or freedom? The relevant charter right in this case would be the freedom of expression, as stated in Section 2B of the Charter. Then the court first confirmed what had been stated in a previous case of the Supreme Court, that commercial expression can be protected under Section 2 as freedom of expression. Then the court said that the particular laws in this case were being used to restrict both a particular range of content and certain forms of expression in the name of protecting children. So the court is saying that these laws made by the Quebec legislature do infringe upon freedom of expression. So therefore the answer is yes, the law in question here does infringe on the charter right of freedom of expression. The third and last question that we need to consider and answer is that infringement of freedom of expression acceptable as a reasonable limit under Section 1 of the Charter? To determine if it is a reasonable limit, the first requirement is that the law must have a pressing and substantial objective. So does this Quebec law have a pressing and substantial objective? The court, with respect to that issue, said yes, it does. If we look at their actual words here, and we'll just look at the first sentence where it says, the objective of regulating commercial advertising directed at children accords with a general goal of consumer protection legislation to protect a group that is most vulnerable to commercial manipulation. And the court goes on to conclude that the objective of this legislation is a pressing and substantial concern. So that requirement is met. The second requirement to be a reasonable limit is that the law only minimally impairs the charter right or freedom. So in this case, does this Quebec law only minimally impair the right to freedom of expression? The court concludes that a ban on commercial advertising directed to children was a minimal impairment of free expression, consistent with the pressing and substantial goal of protecting children against manipulation through such advertising. And the court specifically pointed out that this was not a total ban on advertising these products that may be used by children, these toys, with respect to this particular manufacturer. The court pointed out that advertisers are always free to direct their message at parents and other adults. They're also free to participate in educational advertising, and basically said, this is your problem as advertisers to develop new marketing strategies to sell your children's products. So the court's essentially saying, well, just because you can't advertise directly to children, you can still advertise to their parents and convince them to buy your toys for their kids. And so therefore, this is only a minimal impairment of your freedom of expression. So the conclusion to that question is it is a reasonable limit, that Quebec law is only a reasonable limit of freedom of expression, and therefore that Quebec law is considered to be valid.